Good afternoon. My name is Bryce, and this is my partner, Michael. Today, we are representing Khalid Hassan, a respectable man with no prior criminal history, no credit issues, and a steady job. However, Mr. Hassan's application to become a tenant was denied due to reckless reporting on the part of RealSmart Reporting Services. RealSmart screening told the landlord Mr. Hassan had past eviction judgments, criminal arrests, and more. And therefore, the application did not recommend renting to Mr. Hassan. As it turns out, this history did not belong to Mr. Hassan at all, but four other individuals with varying birth dates, varying spellings of the same name, and varying locations. Mr. Hassan believes the report is especially reckless because it appears the company purposely gives wrong or vague information, so users will subscribe to the premium service, which gives more accurate information. They even include a coupon for money off the previous service at the end of the year's report. This coupon comes right before the fine print, where they claim tenant history may not be accurate at all. RealSmart fails to mention that criminal history may be inaccurate. Due to such reckless reporting, Mr. Hassan lost out on renting his dream home, and he couldn't rent a second choice home either before the report was corrected. Our client, Mr. Hassan, alleges RealSmart violated the Fair Credit Reporting Act, and he is seeking damages, legal fees, and substantial changes to how the information is retrieved in RealSmart's system of reporting. We've come to the table today to reach a mutually beneficial solution, which will redress the wrongs that occurred and hopefully prevent this unfortunate event from occurring again to someone else. The first question that we'd like to address is, what are your client's main interests and goals for the negotiation? The first and most important interest for our client today is making substantial changes to RealSmart's policies. And there are several requirements that must be changed if we're to reach a deal today. Second, in conjunction with substantial changes, Mr. Hassan wants to receive a monetary settlement which covers the embarrassment of being denied and is moved to a house that does not meet his needs.
In pursuit of these goals, our clients have instructed us to address two main issues and some underlying sub-issues. First, changes to RealSmart's policies to avoid similar issues reoccurring. And second, monetary damages in the form of actual and punitive damages and loss of value to our client. Our client has shared some goals, requirements, and preferences for the issues and sub-issues. Our client would like to see RealSmart make substantial changes to its policies to avoid similar issues recurring. Our client would like for RealSmart to provide more information on all reports, whether premium or not. Our client would also like to see RealSmart employ some sort of human review of its reports. At a minimum, our client would like RealSmart to include the full name, the address, and the birth date of individuals identified in the criminal and eviction history portion. Mr. Hassan is also seeking actual damages, as well as the loss of value he suffered based on not being able to find an equivalent apartment following RealSmart's report. Moreover, our client is seeking punitive damages of $100,000 and attorney's fees of $15,000. Our client believes these awards are justified because RealSmart intentionally leaves out key information within their reports. In settlement of all his claims, our client, Mr. Hassan, is seeking $75,000, if not more. Our client is willing to accept less should RealSmart be willing to make substantial changes to its policies. However, in no case will our client accept less than $25,000. Additionally, our client expects RealSmart will require him to sign a waiver of claims, and our client is not willing to do that for less than $10,000 on top of additional compensation.
The second question that we would like to address is, what is our overall negotiation strategy and why? We plan to leverage Mr. Hassan's BATNA, or best alternative to a negotiated agreement. The BATNA is for our client to continue with the court case, which is currently pending, and achieve a ruling that is in our favor. Mr. Hassan is a sympathetic plaintiff, and we believe his case is strong should the need to go to court arise. Second, we are planning on spending ample time in the introduction, establishing a cordial and collaborative atmosphere. This strategy will hopefully make the other side become more responsive to our goals, because on the flip side to our BATNA, our worst case scenario is that we go to court and RealSmart wins. If this happens, we could potentially receive nothing in return. Third, we've come up with a list of potential creative solutions that we can leverage if the negotiation starts to stall.
Also, since our client has shared a sliding scale of acceptability on some issues, such as fees and reasonable changes to policies, we hope to give a little bit within our range on the lesser issues and utilize that leverage on the more important issues to secure an agreement on the higher end of our scale. And lastly, we plan to ask a lot of questions to understand RealSmart's connection to their policies, their willingness to compensate our client, and their motivations behind their policies. If we can understand the why behind these things, we think we can move away from positional bargaining and more towards a principled negotiation, which will ultimately benefit both parties. Thank you.
Good afternoon. First, we want to thank you all for being here and spending your time with us. My name is Josh Flagg.
And I'm Kelly Carlson.
We have the pleasure of representing RealSmart, which is an online credit reporting agency that focuses on tenant screening. Upon receipt of the prospective tenant's info, RealSmart completes a tenant background screening for creditworthiness, eviction, and criminal history. RealSmart is advantageous to landlords because it provides quick feedback on potential tenants. Before we continue, it is important to understand the events that led to today's negotiation. While Mr. Hassan was searching for a home to rent, he was unable to obtain his first or second choices, which led to Hassan renting an apartment. Hassan believes that our client caused the delay in the screening, leading to him losing his first and second choices. Our client does not believe they caused any delay in the process because tenant recommendations come back almost immediately, and the landlord waited for 4 days to make a decision. Hassan now seeks to be compensated for his inconvenience. We have been contacted to come to a settlement agreement that satisfies both parties' interests.
During the negotiation, we will seek to reach an agreement on two primary issues: what policies and procedure changes RealSmart will make to its screening system, and what terms will be included in a settlement agreement. Starting with the policies and procedures used, this issue is divided into two sub-issues. The first is the information that RealSmart will include in its reports, and the second is the introduction of human oversight to the process. On the issue of information used, our client is willing to change its policy. Currently, RealSmart inputs different information depending on the jurisdiction of the state that they are in. They're willing to change their policy to include the names, addresses, and birth dates of individuals identified in its reports. However, they are not willing to exclude information from states where that complete information is not available. Because RealSmart realizes that Mr. Hassan will likely not be pleased with this, they're willing to update their disclaimer to emphasize that the information provided is pulled from public records and that landlords should not rely on it for accuracy. On the issue of human oversight, RealSmart has told us that it is unwilling to implement any kind of human oversight to the screening process before it releases its reports. This would require hundreds of new employees, and it eliminates one of RealSmart's key sales points, which is the speed that it gets its reports out. They are more willing to implement human oversight to review reports after they have been released as a means of quality control. However, given the high costs that are still involved with that option, they would strongly prefer not to implement any kind of human oversight. Finally, on the settlement issue, our client would prefer to keep all costs under $25,000, but it is willing to offer up to $75,000. This includes all damages, costs, and fees. Despite the inherent importance of money, what's really important to our client is that the settlement agreement be contingent on Mr. Hassan's agreeing to waive all of his claims arising from RealSmart's credit screening, sign a mutual non-disparagement agreement, and a confidentiality agreement.
In order to effectively negotiate with the other side, we will spend most of the negotiation trying to understand their client's positions and interests to determine what a successful outcome would look like. Once we feel we have a handle on their positions, Kelly and I will likely call a break. During this time, we will compile the information we've received to create a deal that will satisfy both parties' interests. We have also identified several issues that we can utilize as leverage to create win-win solutions for both sides. For example, we are willing to give a little more on our monetary settlement to ensure we get the confidentiality agreement we want signed. We also hope to utilize our client's greater willingness to expand the information it reports to give less on the issue of human oversight. We expect that as the other side's interests become more clear, we will discover additional tools to use for leverage as well. The issues in today's negotiation are complex and ripe for confusion. However, they provide a lot of room to create different options for an agreement. Because we're dealing with multiple issues, which can get confusing, we plan to ask questions and make sure both parties are moving toward an agreement.
In summary, RealSmart would like to settle this issue and is even willing to provide a monetary settlement and make changes to its company's policies in order to appease Mr. Hassan. However, it is unwilling to make changes that would compromise the core nature of its service, and it will require Mr. Hassan to sign a confidentiality agreement before agreeing to any monetary settlement. We're almost out of time, so I will wrap up by thanking you all for being here today, especially on a Saturday evening. We really appreciate it. Hello, Michael and Bryce, welcome back.
Thank you. We didn't quite know when was best to come back, but we're excited about today and excited to be here.
Yeah, absolutely. You made it. So I will put 50 minutes on the clock. Judges, if we're ready. Okay.
Well, good afternoon. I just want to introduce myself. My name is Josh, and this is my co-counsel Kelly, and we have the pleasure of representing RealSmart. We want to say first that we understand your client didn't get his first or second choice on where he lives, and we just are really hoping that his third option is suitable for his needs. However, we frankly want to just say that we're a little bit confused on why we are brought to this action, as we provide a service for tenant screening, and ultimately the decision relies on the landlord. So if you could please introduce yourselves and kind of give us more of a background on your positions and interests, and we can continue to the negotiation.
Of course, thank you. And we would like to take a step back and properly introduce ourselves. I'm Bryce, this is my partner, Michael. And as you know, we represent Mr. Hassan in this case. And I appreciate you kind of laying out your concerns. And you're a party in this case because our client really was seeking these two homes. He wasn't able to achieve his goals, and it was because of faulty reporting on your end. And he feels like he was wronged, and he's seeking damages today to redress those wrongs. And he's also seeking changes in your company's policies. So those are the two goals that our client has laid out for us to address today. Did your clients expect that, or do you have anything else that you were wanting to talk about today?
No, yes, that is in line with what we were expecting. So could we maybe just, obviously there's some sub issues underneath those top issues. So let's make our agenda a little bit more concise. Can you tell me which procedures it was that you were hoping to review today, and a little bit more on that settlement that you were hoping to come to?
Sure. So I think we would like to discuss the policy changes as it pertains to the information that's included on the report, especially for the criminal and the eviction history. We would also like to discuss damages. We'd like to discuss actual damages, punitive damages, and loss of value for our client being unable to get into the first two choices of his home based on the faulty report from your client's company. So those are kind of our two main issues. And if it's okay, our client has indicated to us that the policy is very important to him, and we would love to start there if that is something that you all would be open to doing.
That is open. Can I just get you to restate one more time what those damages were that you were looking for?
Sure. So we are seeking actual damages, punitive damages, and loss of value based on him not being able to get into his desired home based on the faulty report.
Okay, and just to restate what you said, as for the policy changes, you want to focus on the information used on criminal and conviction. reports.
Eviction.
Got it. Eviction.
And those two seem to be, really the driving factor behind landlords choosing whether or not to rent to tenants. So we feel that some substantial policy changes in those areas would be beneficial.
And I think to start out the discussion on the policy changes, I would like to ask you why your client decided that the elements to include in the report would be full name, address, and a date, whereas there are a lot of other specific identifying factors that could be included, like social security number and things like that. So why were the ones chosen to be in there chosen, whereas some were left out?
Yeah, so it all kind of depends on different factors. So we like to provide, quick responses to the landlord's requests, and we're able to provide that with the information which you stated. But as far as, providing different information, it kind of depends on the jurisdiction and what they have to offer. So that is part of the decision. But just if that doesn't answer your questions, please let me know. But I'm also curious, do you have a copy of the screening in front of you?
We do.
Okay. I'm just curious. So I know you talk about the criminal and eviction reports, and looking at this, are there certain ones that your client was misrepresented by that you know of?
Yeah, I can speak to that, Bryce. So his report details 2 evictions and 4 criminal arrests, or excuse me, 1 arrest and 3 charges, and none of those pertain to our actual client. So they're actually all false. If I'm speaking correctly, Bryce, we just got these facts, very recently, but I believe they're all not pertain to our client. And those ultimately were the reason why he was unable to secure his first choice, which he's obviously upset about.
Okay.
So all 6 of those evictions and criminal charges were referring to different individuals than your client.
That is correct.
Yes, and our client wanted us to stress to you all today that He's a respectable man with no prior criminal history, no credit issues, and a steady job. And he was still not allowed to rent in a house that he was very confident that he'd be able to get into because of what happened. And so he's embarrassed, he's hurt, and that's why we're here today. He just feels disrespected.
Sure. We can understand how difficult that must be for your client. I do want to reiterate, though, that we are simply a service to landlords. We did not make this decision for your client not to go into the home. We understand that this was our report that we ran. But if you look just beneath those negative information details that we're looking at, you see on the very first line, almost right beneath it, it says tenant history cited may not be 100% accurate. And we're certainly open. We're here today. We would like to come to an agreement. We are open to talking about changing our policies and procedures, but we just want to make it clear that we were not the ones to deny your client his home.
Right. Well, just to kind of address those concerns, I'll let you know what our client has told us. First, in your report, it does say not approved in big, bold capital letters. Those are the only big, bold capital letters on the entire report. So it does seem in a way that the decision was made for a landlord, because if you were a landlord with no legal background and you got a report back that said not approved in big, bold letters, you probably would throw the application out. Second, for the note about tenant history may not be accurate, the one that comes after the discount for your premium services, it says tenant history, but you say tenant history may not be accurate, but it wasn't just the tenant history that was inaccurate. It was his criminal history. So it never mentions that the criminal history may be inaccurate.
So I think what that is trying to say is that when we do a research for a potential tenant, that's summarizing the report in general, not just specifics to the report. I understand that, this report has some false claims on it as it goes towards your client. I think one good thing is it's our job to run these reports, and we're excited to, I shouldn't say excited. We're here today to make sure that we can provide, a better reporting system. So I think we're on the same page on what we want to solve. It's just how we can get there.
Yeah. So to that front, maybe we can jump back to those policy changes that your client is hoping to see.
Yeah, I think that's very exciting to hear you say that we're kind of working towards the same goal. I think it may be prudent to maybe talk about, and the name of it is the premium enhanced version, and why your company offers that above and beyond. Is it purely a cost function, or what is the purpose of the premium enhanced service?
I'll be frank, our client hasn't told us about the different services and its rationale behind providing different services. I would love it if you could tell me a little bit more about what your understanding is and what you're hoping to gain from that information.
Yeah, well, I think we're just trying to understand is why is that information that's put behind the paywall not included in the report to begin with?
Can you explain on what information that you are saying isn't included in the report?
The additional details that are involved when you pay for the enhanced report, that these details may be much more helpful to the landlord and may result in tenants being properly evaluated.
Okay. See, and I think we might have a slight disconnect in the information that we are provided from our client. And so I can't give you a real formal answer, but I guess my assumption would be their business model, the way that they make money is that they provide these reports, so they're not going to make money if they provide a perfect, pristine, 100% accurate report free of charge, right? And at the end of the day, our client is a business and they need to make money. So that would be my assumption. I'm sorry, I don't have any more information on that than that, but can I ask what you're, again, what you're hoping to achieve by asking that question? What information?
Of course. So I can answer that. Our client just wanted more information about this premium enhanced version. I mean, really what our client believes is that RealSmart puts information in the report that is intentionally a little vague or intentionally wrong, so that the landlords who are doing these applications, they will go in and they'll buy your enhanced version, spend money, and then be able to correct what they see is maybe not the most accurate information. So our client sees it as a way you're making money off of, maybe leaving some issues on the report purposefully.
Okay. Yeah, and like we've stated, we just don't have facts provided to us by our client on that situation. I can assure you we want to provide accurate information to the tenant, whether they're paying or whether they're not paying. And on that front, I think you would like to see more accurate information on your report as your client was potentially harmed by that. So if we can kind of move on again to kind of those procedures and policies that you would like to see and see where we can come to an agreement on those.
Right. And so I think that the goals that our client have can be served by adding a few more elements. And so I believe that our client would be happy if you could add the social security number into that report, and then also have human review of every report that comes through that's not approved, so that someone can make sure the information is accurate before someone's life is potentially changed.
And our goal is really to just ensure that, as Bryce said, the correct information is being attributed to the correct person so that landlords can make an accurate determination based on the service that you are providing to them.
So you just want to add social security numbers to the information provided?
And human review of every application that's not approved, just to make sure that it's approved for valid reasons and it's accurate.
So kind of having that just out on the table, I'm interested to hear more about the current living situation your client's in. I understand that he wasn't able to get his first or second choice. However, we have very little information about the apartment. Could you please just kind of state more information about the apartment, whether it serves any of his interests, and kind of see where we can go from there?
Yeah, I think we're happy to do that. I think that certainly is changing the topic to talk a little bit more about damages and loss of value. I'm okay to move on to that, but we proposed some issues for the policy changes, and maybe we'd like to finish that a little bit, or at least hear your response to what we offer before we move on.
Sure, and we don't need to move on. Our intent is only just to get a greater sense for all of your interests. We've said some broad agenda items. We just want to get a greater sense for what that's going to look like in practice before we're able to put together a whole package that's going to really satisfy both our clients.
Sure, and I certainly understand that they work in unison, but to be transparent, as I shared up front, the policy changes are our client's main interest today. Not that we also are very interested in damages and we have some minimum requirements, but if we can come to an agreement on the policy changes, I think that would shape, as I'm sure it would shape your acceptability as far as our damage discussion goes. So while they work in unison, they also play off each other a lot from our client's perspective.
Sure, I understand that. And I was just about to tell you some of our opinions on those policy points. So we, as we've mentioned a few times now, we are more than willing to make some changes to our procedures and how we run our reports. It's never our intent for incidents like this to happen. And especially we're concerned by your accusation that it would be willful. I can assure you that my client would never willfully produce wrong information. But if we can do anything to make sure that these reports are more accurate, we're happy to do that. I guess I'm just a little confused. It seems a little sparse. Your requirement is just to add social security to the policy.
So those were what we proposed in addition to what you're already doing. You're already doing full name,
okay,
and address and birth date, but we want to add things to it. And that was a start. If you guys have other ideas you want to throw out, we'd love to hear some of your ideas. We haven't heard that yet, but social security and human review is a good place to start. There are other things that our client mentioned that he would like as well, and we're happy to discuss those as well. Phone number is an option, race is an option, including age is an option, just other details to help verify that the person is who they're supposed to be and not someone else.
sure.
Okay.
Just give us a moment while we review our authorities here.
So as we kind of discussed, we're looking at this together, and they kind of both of these topics go hand in hand. Now that we kind of understand where your positions are in the policies, I know I tried to ask more about the housing situation that might go to damages. I'm not trying to avoid this. I just want to see it as a big picture. Would you be okay with sharing kind of this housing situation that's going on so we can see that full picture?
Yeah, I think so. So we do have some information and some facts that our client was unable to receive or to rent his top two options. Both options were significantly, from his perspective, much better than his third option. His third option is across town. It doesn't meet the needs that he had hoped that the other two options would have met. So he certainly is, unhappy, and he's really displeased and harmed by his inability to get into his first two options.
And to get specifics, which I'm sure you're looking for, the house that he ended up in was a much smaller square footage overall. It has less bedrooms, less bathrooms. There's no free parking compared to the other two. The commute is way longer. It's a 25-minute drive one way. So there's a lot of issues with the house that he ended up in compared to what he saw as his perfect home that he was really excited about.
Sure.
Okay.
Do you have a cost that you can share with us?
Cost for which element or total?
His monthly rent at his current apartment? Just out of curiosity, so I can get this full picture of the three different options we were working with.
So he's paying $2,000 a month. He's paying $1,650 a month at the place he is currently in, but $2,000 a month was for his first choice.
Okay, got it. Yeah, $1,650 at his current apartment, and then the Greenville was $2,000. Thank you.
And I do think it's important to reiterate that the rent is not the function of why he wanted the apartment. There are many other factors that were kind of driving his desire for option one or two.
Of course, we're aware. We just want to have all the facts as we're moving forward.
Another quick question, and this isn't, I guess, super important if you don't have the facts, but I'm just curious, how long is he planning on staying in this apartment? Is it his goal to get out of the apartment soon? Does he have a 2-year lease or anything? Do you have any specifics on that?
I think that it would depend on what settlement we reach today, honestly, is what our client will do.
Okay, so there's a chance he would stay in this apartment. So
We do not have specific information on that, unfortunately, but I do think, as Bryce said, it would depend on our agreement today.
Okay, thank you.
Can you tell me more about the other damages that you're looking to recover, or just in more detail about those damages that you're seeking to recover?
Sure, I can go into that while we're at it. I'll just go ahead and lay everything out in full transparency. And if you have a pen and paper handy, I can break it down for you. I can give you a sum and then give you each different total if that would help speed things along. So the damages that we're seeking are $227,050, $227,050. So that is a $12,000 a year loss based upon where he's at right now compared to the house that he wanted to be in. That is $200,000 in punitive damages, $15,000 for attorney fees, and the $50 application fee, which he paid to your company and received a faulty report.
Sorry, could you repeat the last one?
The $50 application fee that he paid to your company to rent the original house.
Okay.
He wants a refund on that $50 application, considering he received a faulty report in return.
Can you just tell me that second damage that you said again?
The $200,000 punitive.
$200,000 punitive. Where are you getting $200,000 in punitive?
So that number is what our client reached after doing some research into this case in particular. He believes that it violates the Fair Credit Reporting Act. And if we were to go to court, Mr. Hassan knows that he is a very sympathetic plaintiff. And if we were to go to court, a judge could award punitive damages with no cap. And we could very likely receive even more than $200,000 in damages. So that's how we came to that conclusion.
Okay, I'm just curious, because we don't have that case in front of us, was that on someone's decision to be in a certain house, or was that more of the application process? I'm just curious kind of what went on there.
I'm sorry, I didn't really hear your question. You were kind of,
I'm just curious. I know you have that case in front of you. And is that a case where someone was not able to obtain their house or tenancy because of a report, or because of a landlord's choice of who was able to be there?
So we don't have a specific case in front of us. Our client is bringing the case today alleging violation of the Fair Credit Reporting Act, which if you don't have, I can read you parts from the statute.
We're familiar. Thank you. Okay, we're just trying to get a greater sense. We're not necessarily challenging anything right now. We just want to get a sense for where your client is and and why exactly. So I want to jump back to that 12,000 per year loss. Can you tell me where that number is coming
Yeah,
from?
I could touch on that, Bryce. So our client has calculated that based on the amount he's lost not being able to get into his first preference. So the apartment that he is in now, the third option, it is 550 square foot less than his desired, and he calculated that at $1 per square foot. The bedrooms, it's one less, which he calculated at $50. There's half a less bathroom, which he calculated at $50. At the new place, the third option, he has to pay for parking, which he included. The garage has one less spot, so he's gone from a 2-car garage to a 1-car garage. The commute is 25 minutes each ways versus only a 10-minute commute at the other option. And then he also subtracts some from that calculation for the third option being less rent. So he does factor in that he is paying less, but the loss in value he adds up to get to that $1,000 a month, and $12,000 is 12 months.
And I think Michael might have missed the parking cost being an extra $100 for him to pay for the pass, and the garage value being $200 in his eyes for not having the extra space. So if it's not adding up to 1,000, we can help you with the math and the breakdown of it.
So it's basically 1,000 a month is what.
Correct. And
That's correct.
He's asking for 12,000 because he assumes he'll live there for at least another year until he finds something else.
Okay.
Okay, so here's, unfortunately, I'll come back to that. Just let me continue to go through the rest of these damages, and then we can talk about them all at once. So attorney's fees, 15,000. That seems a little high. Can you tell me a little bit more about that?
So unfortunately, we don't have that information. Me and Michael represent Mr. Hassan, and those are our attorney's fees that were mentioned by our client and that he wants paid for. So that is the exact amount that we are bringing to you.
Okay, got it. Thank you. Okay, so on, I'm gonna jump back to the issue of the payment for the house. So we've done a little bit of our own research on the market value of those houses. And it looks to us like Gravio was worth a little bit more than the market value for it. And so we think that Mosio is a better comparison for the true loss that your client suffered. So given all of the math that goes along with that, we think a more reflective price per month is $250.
And that would be total. So that is including all of the garage loss, the parking loss, the commute loss. You're offering $250 per month for all of those losses.
Correct.
You know, because that, of course, the market value factors in all of those details.
Right. And could you expand on the market value? I'm a little confused. I know Mosio was our second option, but can you talk about the market value? Is that factoring in all of the functions that we talked about, or is that just talking about the rental value?
And the market value, he's a renter, so I'm not sure he's really concerned with the market value of a house.
And I think that was kind of what my question was getting to. I just like to understand a little bit better what market value includes or means.
Sure. And unfortunately, I don't have quite as detailed of a breakdown as you do, but I think on a general basis, market value includes, you know, what a market would buy. Of course, the general market is going to consider a 4-bedroom house as more valuable and worth more money than a 2-bedroom house. So I assume you mentioned that he was in a less desirable neighborhood. I assume that also brings the cost down. I think it's pretty self-explanatory on that. And again, I'm sorry, I don't have a more detailed information from you, other than that we were able to run the stats on our own, and we came to that being a more reflective damage amount.
Right. Well, since our client was using your services to help with his rental, he's not interested really in discussing the market value of the home that he ended up in because he's a renter. I think him taking $550 loss, only calculating in $1 per square foot, which we all know houses don't go for right now. That's what he's calculating as his loss for just living in a smaller home in general. So I think that's kind of a better judge than the market value of a home, is to look at the size decrease from a smaller house that he moved into.
So we might have some disagreement. Yeah, we might have some disagreement and confusion on kind of what we're calculating here as value of the home, and how that affects rent. I think we can both agree that, a larger home is likely to be more expensive than a smaller home. So we'll factor that into our calculations. I don't want to get caught up on this one issue. Is there anything else as far as damages that you think is necessary to get on the table before we continue the discussion?
I think that the $227,050 is what our client sees as fair for this case, and we would love to hear what you have to say about those numbers.
So unfortunately, that number is going to be a little bit high for us. We're flexible with you. We're willing to work with you on the policies and procedures in exchange for bringing down that damages. And it seems like, fortunately, that is a greater interest point for your client. I have to say, I'm a little confused because RealSmart does use their social security numbers for a number of its searches. So I think I'm still just not having a great understanding of what it is you're looking for with this policy. And I know I've asked, but it's just not, if you could just break it down real simple for me, I'd appreciate it.
Yeah, so
I understand the human review component.
So we're leaving the discussion of damages and going back to the policy changes again?
We're just trying to get a holistic view of everything so that we can create a package. Yes. And I think that requires us knowing everything.
Okay, well, so the social security number, you do have one down for Mr. Hassan, but all the other people that you mentioned who have different spellings of names, who were born different places, different dates, different charges that were not our client, there was no matching of those social security numbers. So every negative information detail that we have on our report should have had another social security number there to make sure that we're talking about the same person. Whereas you put his social security number at the top and then listed all these charges from other people, but there's no way for anyone reading it to know that the social securities don't match and that we're talking about different people entirely.
So I'm sorry, continue.
I think our major issue is there's no verification of the results that you are pulling are actually being tied to the person you're searching. So we want to make sure that the results that are gotten are verified in some way. And this is one option that we've come up with to verify the results.
Okay. Yeah, and I appreciate you saying that. We would like these results to be accurate, as we've stated as well. So I think we're right on the same page here, trying to come to an agreement. I do want to touch on the human review factor. So one of the prides of our client is that they're able to get these reports back in a fast manner, so that people who are trying to get the homes that they want can get into them. So I know Mr. Hassan wasn't able to get to his second home because of the decision by the landlord taking 4 days. And by the time he got to that one, it was gone. I also understand that at some point he is looking to move out of the current apartment he is in. And I'm assuming there will have to be another tenant report that is used. So when it comes to human review, that delays the process significantly. It doesn't really get to all of our interests because it still would cause problems with getting your first choice of home, whether there is a big delay. We would not, I'll be frank, we don't want to do human review because we want to keep our process streamlined and keep it fast. And I think that also helps your client as well, trying to get into the homes. As we know, it's a competitive rental market and you're not always able to get your first option.
However, with that, we do have a little bit more flexibility on that, on the information included. And I just wanted to take a step back and give you maybe a greater sense of the reason why the report looked the way that it did. I think my co-counsel Josh mentioned this a little bit earlier, but we did kind of breeze past it. Unfortunately, different jurisdictions require and provide different information. So oftentimes a jurisdiction will only use a first and last name and a birthday to pull these public records. So it's not always our decision. And that's why you do end up seeing these mistakes that, we will admit that there were mistakes on this. That's why you see those, because different states have different jurisdictions. However, I'm I hear your concern, and I think there's an opportunity for improvement. Our client would be willing to include the more specific information on what that report said. So on the report that we're looking at here, where it's talking about those negative information details, it would say more specifically who it was about. So if it was only drawing from his name and birthday, but it didn't have that social security or the address connected to that crime or that eviction, then it would say that. Does that meet some of your clients' needs?
I think that it's a step in the right direction. I'll say that. And I really appreciate you giving me the enlightening information about the different jurisdictions and things like that. You know, my client and Michael and I, we're not involved in this business of reporting, so we've never would have known that. So I appreciate that. Going back to what Josh said a minute ago about your company priding itself on being quick, our client fully recognizes that. But his sentiment to us is that quick isn't always best, and there needs to be some type of authentication verification. And he really wants to push for human review. We originally asked for full human review, but we are willing to negotiate in good faith on what that means. So if you aren't willing to review every single case with a human, can we at least agree that there needs to be some type of way that a human reviews every non-approved report? Would that work instead of reviewing every report in general? That would probably cut down on a significant amount of your cases.
I think, that's something that we can definitely discuss and think about. I'm not able to commit to that. I'm just saying, or I'm just thinking in my head, even if that was the case, would your client have gotten the second choice? Because it is not approved. We want to ensure accuracy, and we're working on ensuring accuracy, but we also just want to make sure, these are up to date and that the process is as efficient as possible. So I'm trying to think of a solution that can keep that kind of quick report, but also provide more accurate information. And I'd like to keep it focused on that.
So Michael and I have offered several different things in regards to the settlement of damages and of the policy changes. We've come up with a few different solutions, and I think that we're negotiating in good faith. Do you have any offer countering to us that we can take into consideration or at least talk about?
I did just offer you that change to the way that we run our reports and the information that we provide on our negative information. I was hoping to receive a response on that.
Well, we just don't really see that as much different than what's already being given. I mean, it says what the charge is, such as a criminal arrest. It has the date and it has the place of the arrest. So I'm not really sure that what you're offering is going to still be able to be verified. I mean, that's our main concern.
So I think it's going to show more information, and it's going to maybe raise a red flag for landlords when they see that maybe some of that information is missing. Because, right now, I can admit that this looks a little bit like it's confirmed that he had these evictions. And, we have that disclaimer on the bottom, but I can see why there's concern about that being confusing. And I think making that change where we include where this information is coming from, like how we found this report, I think that's going to draw a flag for landlords. And so I think that's going to be a little bit more significant than you're giving it credit for. However, I hear you. And so I am willing to make another change to update our disclaimer to make it a little bit more obvious to landlords that this information may not be 100% accurate.
So we really appreciate that. And that's something that we are interested in. I think we're headed in the right direction. I think a couple things that maybe we could begin to set in stone a little bit more is on the back portion where it talks about the criminal history and the evictions. I think we would need the full name, the address, and the birth date for those records to be included along with the change in the disclaimer. But I think there is some more discussion to be had on the topic of human review. We are not prepared to totally take human review off the table. I understand your concern about ensuring that the process moves along quickly. And I think you said that this is a situation where our client may not have gotten the house if there was human review, but frankly, he's a pretty good, test case for what's wrong with your client's program. There were 6 faulty things about him, and he was disapproved for that. But I think we would like to maybe counter with a randomized review of certain reports. So we're further limiting the amount of reports you're reviewing, which we're doing in good faith, but we are ensuring that some human review is taking place to verify these reports.
Okay. And how would that randomized review be run? Would it be on a certain amount of reports that are given, or is there just kind of an idea that we can expand on in the future?
I think that taking a substantial percentage of the reports that were not approved and being run through a human verification system to be able to verify what's included in your report is something that we're looking for. So we can, I mean, even if you don't want to do all of the reports not approved, we're willing to negotiate that. I mean, how do you guys feel about that idea?
It's something that we're open to discussing, and I appreciate you guys coming forward with so many ideas and letting us know all of your clients' interests. I think at this point, Josh and I are going to go take a little break and just look at all of this information and see if we can come back with something for us to try and package together. Does that sound good?
Good idea.
Okay. We will be back in about 5 minutes then. Thank you for giving us that chance to kind of reset and look at everything that we'd gotten on the table. We did have a chance to look at everything, and we think we have a proposal that we might be able to talk about going forward and hopefully come to a resolution. So I think the policy change that I had just proposed that we had discussed about adding all of the information that we have about that negative information right on the report, we're willing to make that change. And we're clear about that. So that's the different jurisdictions provide different information. So we're not always able to provide that full information, but we will provide all the information we have. So it will be really clear where there are gaps.
So
Any questions on
that would be the full name, address, and birth date of individuals that are identified in the criminal and the eviction history of the screening reports.
Yes, where we have that available. However, not every state provides all of that information. So if we are talking about a state where that information isn't provided, it will be really clear that that information is not there. So that will set off an alarm in a landlord's head.
We definitely,
And that's just,
we love to hear that, and we want that included. Did you guys come to an agreement about the offer we made regarding the human verification? I
will keep running through our offer. So as for damages, unfortunately, we are just not authorized to give you that much money. So we are bringing that down to $40,000. However, hearing that your client appears much more interested in the policy changes, I think we are willing to give a little bit more on that front. We did have a chance to discuss that adding a human monitor, and although our client will not love that aspect, we are willing to add that randomized human monitor afterwards. And we're also willing to add that disclaimer. So I hope you realize that we're taking it very seriously, that we're dropping this damage amount, and we want to make sure that your client's real interests are being heard. However, also on that, because with that randomized human monitor, we are taking a hit on our client. We're going to have to insist on an agreement, which will include a waiver of all of Mr. Hassan's current and future claims against RealSmart, a mutual non-disparagement agreement, and then a confidentiality clause where he agrees not to discuss today's settlement.
Okay. Well, we really appreciate
that is everything on the table. So I would love to hear your response.
Perfect. I'm glad that we were able to get a counter to the offers we made. So first of all, the policy changes originally that you mentioned about the individuals identified in criminal and eviction history, we would love to accept that. We will gladly accept the random draw checking by human verification. We just need to get some details from you all about what that actually means. What percentage are randomly drawn? And are these employees of yours that are doing the human verification, or is it a separate company, or how does that work?
So I think we'd have to kind of discuss that with the client to get a better grasp on what we are actually able to provide. But going forward, I think I can give some kind of general ideas, whether that is, a certain percentage of the reports that we run, and we check those by an internal source or an outside source. I think that would be sufficient enough to make sure that these reports are being monitored, and that if there are consistent mistakes, they are verified. Does that kind of explain?
Yeah, I think that's probably sufficient for what we're trying to accomplish today. I know we are running a little low on time, so I think that is a tentative agreement that we can maybe circle back on after we both talk with our client, I did want to talk briefly about damages and the disclaimer. As you said, our client is, or their most important purpose today was the policy changes, but they are also interested in damages. And the 40,000 number is very close to what our client was hoping. And with that said, though, the waiver was something they were a little worried about. And I think with the waiver, we would need a little bit more damages, but we are open to signing the waiver and all the other things that went along with that you asked. So I think if we could maybe bump the damages up as a lump sum to 85,000, we would be willing to sign the waiver and everything else, that the NDA and all the others, and we would be willing to agree to everything else we had talked about.
I am very happy to hear that we have reached an agreement. It seems like on all of the other issues, that 85,000 is still going to be a little bit high for our client, but I am happy to hear us getting closer to a number that works for our client. Like I said, we are giving on this, the human monitor for our client. So I need to come back with something that's respectable here. We would be willing to raise it to 50,000.
So I'll just let you know up front, our client, since he's not super happy, did not want to sign a waiver, but he did tell us that to sign a waiver, he would need additional monies on top of his minimum. So we're willing to keep negotiating with you, and we're able to move down to 75, but we're still a little far apart, and there's really very, very, very little wiggle room on what we can do if you want that waiver. But if you do want a waiver, if you don't want a waiver, we can accept less money. But if you want a waiver, we're going to have to kind of stick towards the higher end, which would be about 75 is what our client's asking for.
We understand, kind of whether there is this disclaimer and whether there's not. Price. It is important for us to have a disclaimer, some sort of agreement that says that. However, I think we're still a little high on what we would be liking to give as far as a settlement agreement. The issue is we also have additional costs to our company for paying for the human moderator. And so being able to protect their interests, it's important that it encompasses the whole agreement here. So we would definitely need to come down from that.
And if you're looking for that a little bit higher monetary settlement, then we're open to discussing dropping that human monitor, because as my counsel Josh just mentioned, that is going to be a large expense for our client.
So we're not willing to drop the human monitor. If we do that, our client has instructed us we must ask for more damages, unfortunately. So let's stick with what we agreed upon with the changes in the policy. And can you counter my $75,000 offer?
Yeah, 1 second here. Let's just look this over again so we have a full picture here.
Yeah.
And I think it's important to note that our client sees this waiver as a pretty significant compensable give for your client. And we know it's important to your client, and we're happy to give it, but it's a pretty big ask of our client. And although we're willing, he does want to be compensated for doing such.
Okay, yeah, we understand. Just looking over the agreement, would 65K be an agreeable number as far as the settlement? That's kind of where our client would like to stay at, and we'd like to hear what you have to say about that.
So we will accept $65,000 for the settlement of the damages, including the waiver of fees. And so just with the last little bit of remaining time that we have, I'll do a quick recap to make sure we're all on the same page. So we just agreed to your rebuttal to our offer at $65,000 to settle all claims, including the waiver that you mentioned. And then with the policy changes, we're looking for that, the full name, address, and birth date of individuals identified in the criminal and eviction history of the screening reports. And then we're also adding the human review aspect, which will be a random drawing. And I think.
And then the change in the disclaimer as well.
Yes.
Yep.
Okay, we are on the same page. I think we have something good and concrete to bring back to both of our clients. I guess we'll be in touch in the next few days, following up a little bit more about what that randomized human monitoring system will look like. But otherwise, this was great. Thank you both for being here today.
Thank
Yeah,
you.
we'll
I'd be
write it
happy.
up. Sorry, Michael. I was gonna say,
I was
we'll
gonna
write
say
it
the same
up.
thing. Yeah.
Thank
We'll
you
keep an
guys
eye out
so
for
much.
it. Thank you.
Yeah, thank you, Michael. Thank you, Bryce.
Okay, Josh and I will now go to our breakout rooms, and I think Team 20, you'll come back in 5. Great.
All right. Thank you so much. And we're going to answer this question in reflecting on the entire negotiation. If you faced a similar situation tomorrow, what would you do the same and what would you do differently? I'll start out by talking about what we would do the same. We are overall really happy with our performance today. We achieved a great resolution for our client. Michael and I came into this negotiation today with what seemed like a weaker argument, considering we were one individual going up against a really large company. However, by implementing negotiation strategies, we were able to build value and leverage, which ultimately led to a great deal. We leveraged our BATNA, which was going to court and potentially winning, and I think the other side agreed that that added value and it kept the negotiation rolling. One thing we did well was actively listen to the other side. Once they said that they were willing to accept some form of human verification, we took that concession and we tried to make the best deal possible for the policy changes, which was our client's overarching goal. Mr. Hassan told us he wanted a settlement of $75,000, but he was willing to settle for as little as $25,000. So our end negotiation at $65,000, including all the extra policy changes, was a really, really good deal for our client, considering he was willing to go to as little as $25,000. And he received all the different policy changes, which adds a lot of value to him. A third strategy we did was ask questions and explain. We were careful every time we made an ask to explain the why behind that ask, so the other side didn't think we were just throwing out numbers to positional bargain. Our initial ask for $227,050 seemed like a lot at first, and we did not come into this negotiation expecting to give that amount right away. In fact, we hoped to make progress on policy changes first, which our client instructed us was very important, and this would allow us to decrease the max damages that we asked for. The other side wanted to get a full picture, and we had to explain to them what our full amount was and be careful to relay information on how the sum broke down. We justified every expense, and I think overall the other side understood where we were coming from in the end. Our client will be thrilled we settled for so much more than our minimum authorization, and we accomplished all the secondary goals our client laid out, including more money for signing a waiver and adding additional policy changes, including the much sought after human review. We also spent additional time in the beginning establishing goodwill and a cordial attitude, which I believe kept the negotiation from becoming too heated on a topic that we all know has strong opinions on both sides.
Although we were able to make an agreement today that greatly benefited our client, if we had the chance to act differently, I think we should have or could have begun the negotiation with a better distillation of the sub-issues within each topic. Although we were able to come to an agreed upon agenda and starting point, I think by better distilling the sub-issues, we could have been more structured and effective. However, Bryce and I were quick to discuss the policy changes topic because our client shared that was his primary focus within the negotiation. And he shared that the agreement on the policy changes would guide our agreement on the damages negotiation, which was a goal that we greatly achieved. However, I do think that if we could have begun with a better distillation, we might have been more successful, maybe a little more effective in the overall. Bryce and I also got a little bogged down on, and I think the other side might have as well, on the actual changes to the policy that we were seeking. I think a bit of this was to do with the fact that we didn't have a ton of time to digest and understand the facts, but we eventually got to the right information on what they were willing to do and what would meet our goals. We also didn't take a break. Although the other side did take a break, we were considering taking one at about the same time. We also considered taking one after they made their counter offer. However, it would have not left enough time to come back. I think it would have benefited us to take a break, but we were able to benefit from the other party's break. Finally, I think we also could have began the damages negotiation with a lump sum damages. Bryce discussed how the other party really wanted to know our breakdown, but I do think when we got into the market value, the negotiation broke down. However, ultimately, I think the negotiation was extremely successful for our client. We completely met our interest, and we were very happy to take this agreement back to our client. Thank you, and we'd be happy to answer any questions if we have any time remaining.
I do have a question. Can you hear me okay?
Yes, ma'am. Oh, I'm sorry. We
Now
actually
we
can't hear
can't
you
hear
now.
you.
But now,
Yeah, a little bit.
you said that you were arguing from the weaker position. Is that, I just want to clarify what you said.
I didn't really mean weaker position. I just think that when you have one client who's talking about renting houses and just he's going up against a big company. And so while we do have a good legal argument, you know, obviously we're at a little bit of a disadvantage going up a big company, but we were very secure in what our legal position would be. And I explained that to the other side that we are willing to go to court. We do believe that it violates the Fair Credit Reporting Act. And there's a potential that a judge could award more than we're asking for. But anytime you have one client up against a big company, I mean, there's always a difference in position.
Okay, thank you.
You're welcome.
Thank you. We'll return to our room and wait for feedback coming up.
Okay.
Okay, so I will put 5 minutes up for us. You know, to start, Josh and I will just kind of talk a little bit about the agreement that we came to and our reflections on it. But if at any point you have any questions or comments, please just feel free to interject. So overall, we feel like this was really successful. Like our client is going to be satisfied with the settlement that we came to. Fortunately, we were able to stay within all of our authorizations. We made changes to our policy on the information that will be provided on the report, but we did not have to exclude information from states that have less information, which was important to our client. On the issue of human oversight, we did have to concede a little bit on this, which was against our client's preferences. However, it was within our authority, and we didn't give it up for nothing. We were able to use it to drop the damages that our clients would have had to pay significantly from their proposed initial offer, which was approximately $230,000, which was way outside of our authorization, down to $65,000, which was $10,000 below our client's ceiling. And we were also able to secure that non-disclosure agreement, which was really of the utmost importance to our client. As for things that I would have changed about the negotiation, I admit that I was a little confused on the calculations for the housing damages. So I would have liked to have been a little bit better versed so I could have handled that conversation a little bit better. However, we are fortunate that when we countered with that significant drop, they didn't challenge my knowledge too aggressively to support it. And fortunately, their client wasn't as interested in the damages as they were in the policy changes. So we were able to kind of cover that up pretty quickly.
And as far as our strategy and structure of the negotiation, I spoke a little bit in the preview about kind of how we would conduct this. It was our client or our goal to see all of their clients' positions and interests collectively before we were able to come to a solution. And as we started, we tried to process all their interests, and they wanted to stick on the policy. So we continued to ask questions to make sure and kind of give them an overall view of why we wanted all these different structures and issues that they presented. Once we were able to find most of their interests, we were able to take a break. And that's when Kelly and I got together and discussed the different options that we had to settle an agreement. And I think when we came back, the agreement that we had ultimately wasn't the one that we decided, but it was a significant portion of what we agreed on. And being able to have those interests before we went to the break provide us an opportunity to create that solution that ultimately led to the overall agreement. I think one thing that I would have changed during the negotiation is I forgot to mention the non-disclosure and contingency or non-disclosure and confidentiality agreement early in the negotiation. So we didn't actually understand that that was important to their client until after we came back with a proposal. And that kind of changed what our overall settlement amount was. But I think even without providing that information, we were able to still effectively negotiate a settlement that our client is in favor of. So overall, I think I'm very satisfied with how it went. I think our client is also satisfied with the solutions that we came to. And I'd like to open it up if you have any questions for us.
It's a comment. I was curious that you never really referred very much to any of the law that underlies this issue. In particular, the punitive damages request seemed to me particularly high, and the Supreme Court's treatment of punitive damages is much more modest, a multiplier of maybe 3 times actual damages. Here, I was a bit confused as well about actually what the actual damages claim was. But if you take that 3 times multiplier, you don't get anything close. It's something that could have been used, I think, in the argument, but you didn't. I don't know if you're aware of this or what.
Unfortunately, we're not aware of that. We were given these limited facts. I don't recall seeing it in the information that we were provided. Perhaps I missed it. But we didn't have that, but that would have been great to know, because I agree the punitive damages that they came out with seemed exorbitant. But fortunately, we were able to bring them down, even without the knowledge.
Right, well, if there's no other questions, I see we're kind of getting to our time limit, and I just want to thank you all for being here, and taking your time to judge our competition. We really appreciate your time.
Yes, thank you.
Okay, I think we can start the feedback if everyone's ready. Can't hear me? Okay. I'll go first because I have no idea when my mic might go out. It could be any second. First of all, both teams, you guys did such a good job. I was interested and enthralled from the beginning to the end. If you all can't hear me, please somebody raise your hand or something, because I don't want to keep talking and you can't hear me. Okay. I'll start with Kelly and Josh. I thought you guys did a great job. In my opinion, you guys had the way more difficult case to negotiate. You were kind of coming into it almost, admitting fault in this thing. So I think your primary goal was to minimize the damage as much as possible. I really like, Kelly, how you open everything up. Very, very nice, very conciliatory. And Josh, you guys were very laid back and easygoing. I think when you're coming into a negotiation in the position that you're coming in that way, that's how you want to be. You want to let them know that you're there to talk this out, see how you can work it out. And I think you both did a really good job of that. Just to keep it very brief, I think what I really liked is your directness. You asked so many questions. I was wondering when the other side was going to lose their patience, but I really like that you did that, because in your position, the best thing you could do for your client is to find out exactly, what does the other side want, and in a lot of negotiations, you won't be able to find that out. So I think you guys did a good job of getting to a lot of that, and you worked well together and did that. I think your post analysis was spot on. I think you got in the weeds a little bit with the, and it's risky, when you say market value. Well, you need to be able to have some information to back that up, because, and as the other side did, they went right in on you with that to challenge you on that. So I think your analysis of that was good. But good job. And for Brian and Michael, I think you guys did really good. I thought it was very interesting that you thought you were coming in from a weaker position, because I hate to see you guys if you felt like you actually had the upper hand, because I mean, you guys really went at them. You didn't give an inch. I believe you controlled the negotiation from the beginning, and you did a really good job. You had an excellent grasp on the facts. You guys seem like you knew every single detail inside and out, and I thought that was really important, because it gave you that leverage to challenge and counter, and you caught them off guard at least twice. So I think that was really good. You did a really good job of that. You worked really well together. I like how you sort of tag team, and went in when the other didn't finish something, you were right there to say, oh yeah, my partner missed this. So I think that was really good. So just excellent, good job, great job making it this far.
Well, let me jump in then very briefly. I second everything that's been said. It's clear why you are all here. This was an incredibly good negotiation round. And I want to compliment both you and the ABA for encouraging the development of this particular skill. Once I had a possible job, which never came through, but it would have been to go to a foreign country to teach the leaders of that foreign country how to negotiate with the major oil companies. That says how important these kinds of skills are in the practice of law. But getting to the practice of law, I don't know whether it's within the purview of this competition to consider whatever constitutional constraints there are on punitive damages. I think it's somewhat relevant to it. But I do know that you have a statutory provision dealing with the Fair Credit Act that's clearly in the record. And what, besides one passing reference, not to the details, not to the language was never used. The passing reference was all I recur. And on the Hassan side, I was surprised that you didn't use that. Maybe there's a reason for that. The thought that occurred to me as well is that it's in the interest of RealSmart to make sure that their system is working. And you could have argued that, but maybe you didn't need to because you successfully got the statistical sampling human review. You could have argued that to them, that really it's for their benefit. They don't want to have more cases like this in the future. They should know what's not working or what's working well. And the only way to do that, I think, is with some sort of random sampling. So in terms of the costs involved and what have you, a full review, I think, is probably not likely to be commercially feasible. But besides the comments about the legal issues, wow, you all worked well together, both within the teams and between the teams. And that's really important in negotiation. So I am impressed. Congratulations. Oops. I just got somebody burging in. Anyway, congratulations to all of you. You're all winners. Of course, I have no idea who won. That's another issue.
Okay, so I'll comment that you all were great, and I can see why you all ended up in the final round. I have no real criticism, except that sometimes it seemed that you were a little bit rote, like you were reading from a page, and you should try to avoid that in this kind of situation, or even in a courtroom situation. But otherwise than that, I can tell you that I've done my ballot already. My ballot was very close. So you both really did phenomenal jobs, and you should all be proud of yourselves.
You're muted, Judge. Now you're on mute. Oh, now you're muted again.
How about that?
That's good.
Okay, sorry about that. I'm a product of another century, so you have to excuse me. Like a couple of the other guys here. This is fun, isn't it? When you stop and think about it, and you think about your days in law school, you'll say, doggone it, that was just about the greatest fun I ever had. The realization of going to a national competition with a bunch of old fogies, excluding the female judge, judging us and looking at us and telling us what we were doing right and wrong. It'll be a wonderful, wonderful memory for you. Anyway, all of you are great kids, actually students and potential lawyers. I hope that you will enjoy your careers as much as you enjoyed participating in a vigorous competition. Because after all, that's what the law is. We go up against one another and try and earn a living every single day, do it in a very courteous way, but we try to be as forceful and demonstrative as we possibly can. And you folks certainly demonstrated that today by being forceful and demonstrative. Taking you one by one, Bryce, I thought your lead off was very good. You articulated what the goals of the client were right from the outset, talked about the maximums and minimums in your position, and actually explained what your strategy was going to be. You made no bones about it. When I listen to strategy in negotiations, I always ask myself, do I honestly believe that the party speaking at the moment has done all he or she could possibly do to facilitate a resolution of the matter? And in your case, I think I can answer that clearly in the affirmative. So that was good. Gave me a good feeling. I won't belabor the point. Your other judges have mentioned all of the good things that you did. I don't want to repeat them all over again. So I'll leave it at that. Okay, Michael, we share more than just the name. Just so happens that's my first name, so I can relate to you. You were a good participant in the entire proceeding. I think that what you did complimented your teammate, and that is really important, that the two of you join together in presenting on a joint basis the very best position of your client. I got the sense that you truly enjoyed being here today, as did your teammate, and I'm glad that you were able to present your position as clearly as possible. And now to the other side. Kelly, you really shined like a bright star today. You were tenacious. You were on the ball throughout. You didn't sound flustered at any point. You were ready to respond and respond intelligently on everything that was thrown your way. I think that you were able to get the negotiation into what I call a scale process. I don't know, what do I call it? Well, it was scale. You could work your way up or down as the case may be, depending upon what the response of your opponent was. And that is a great talent, to be able to be flexible enough not to get stuck in one position and just say, I can't move. You can always move. Whether you like it or not, client has given you parameters, and clearly, so long as you stay within those parameters, you can move up and down, and you did an excellent job. Josh, I must confess, I had some trouble hearing you. So to some extent, I'm a little disabled in terms of evaluating what you were saying, but that's probably more my fault than yours. So once again, I think you worked nicely with your teammate. You made sure that there was nothing that was left uncovered. And I think that you too enjoyed being here today. I occasionally saw a smile on your face. So participants, my congratulations to you all. You're going to have a great future, and I will leave it at that.
Just quickly, Bryce.
Hold on.
My apologies.
That's okay. Judge Weissman, we have a question about your ballot. We're going to move you into another room, and then we will ask your question, and we'll pop you back. And then Judge Brisbane, if you had some more comments, then we'll let you do that, okay? All right, Judge Weissman, they're going to pop you into another room.
Okay, here I go, popped.
Okay.
Oh, I
I'm
apologize.
interrupt you. Go ahead. I'm sorry.
I just wanted to apologize. I called Bryce Brian, so I just wanted to apologize for that.
No worries. Thank you so much.
Yes, thank you all for your feedback today and for taking the time to judge us. We really appreciate you taking the time out of a Saturday evening to do this.
This was
Thank
very
you.
helpful. Very
Yeah.
helpful. Thank you all.
Thank you, Josh and Kelly, as well. We enjoyed it.
Very
Yes,
much.
yes, you guys were great competitors. Thank you.
Thank you.
They asked me to announce, which means, if you remember from yesterday, I'm a clapper. So now when we announce, we're going to clap. So the first thing we're going to do is we're going to clap for the finalists, the judges, and your coaches. Are you ready? Here we go. Wasn't bad. Okay, it wasn't bad. All right. Congratulations. It was very close, but on the number of ballots, the winning team is Team 20. Now, guys, I'm sorry, yes. The judges are very interested to know where you attend school. So Team 21, congratulations on making the national final. National finalists should go somewhere at the top of your resume. Tell the judge where it is that you attend school.
Sure, yeah, we go to the University of St. Thomas in Minneapolis, Minnesota.
Very good. Congratulations. And
Thank you.
Team 20, our national champions, tell the judges where you attend school.
We attend Mercer University in Macon, Georgia.
To our memory, Mercer has never won the negotiation competition. So not only are you a national champion, you're the first one from your school, I believe. So that's it. Congratulations. That's all I have. Erica, what do you have?
Thank you all so much. Really
Congratulations.
appreciate it.